the station of the products or services discussed in the program. The station does not guarantee the results of any investments made by a listener to this program.
The Word on Wealth with Gary Quackenbush is sponsored by the Word on Wealth Radio Network.
This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary is a San Diego financial solutions attorney, protecting people like you. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. Now,
you're live. Happy Monday, everybody, and welcome to the Word on Wealth. It's so good to have you along. This is fun stuff, man. All right, so hopefully you've been listening every day to this show. I've been told by a lot of people that have come in to see me that they are enjoying the content, which is it's thrilling for me because that's kind of my goal. Totally my goal actually is to get content out to everybody of all this information. I've been having a lot of conversations with people about how to be a successor trustee and the different, the subtleties and nuance and even just the big stuff on how to manage as a successor trustee. I was talking to somebody about, setting up an estate plan and who should you have as your successor trustee? Should it be your most responsible child? I'm assuming your kids are all, adults and financially responsible, or at least, financially mature would be preferred. Well, let's just assume you have 4 kids and you're trying to decide which one to have as your successor trustee. The conversation with me, it's basically like, who do you want to have do it? And you kind of toy between, oh, let's have our daughter because she is so financially responsible and she's such, she's good with her family and whatever. And we just like the fact that she's responsible. Or let's have our son because he's the oldest and we just want to go in age order so that we can be fair. And I jokingly tell people when they ask for my recommendation and they say, well, Gary, what do you suggest as being, who should be your successor trustee? To which I ask, which of your kids was the most difficult to raise? Which one gave you the biggest run for your money as a child? And almost every time the husband and wife will look at each other and just laugh and go, that would be Jacob, or whoever. And I go, tell me about it. No, he could never be our trustee because he was really difficult to deal with. He's, not super responsible financially. He's just like all over the place. What's he doing now? Oh, he's got his own business and he's doing really well, but he's all over the place. But man, he was a pain to raise. And I'd say, perfect. That's your guy. Because why? I don't know. Halfway I'm doing it in jest, but halfway I'm not. They say, well, what if we do use him, what if he steals the money of his brothers and sisters? I said, well, then his brothers and sisters will probably go over and burn his house down. I don't know what they're going to do. What do they do when he goes off the rails or does something stupid? Well, they're going to check in. So I point out that as long as your successor trustee starts doing their job when they're supposed to, which means after you die, your successor trustee has a job to do really quickly, like within 30 days of the date of death, that successor trustee is required by the probate code to file the will with the California probate court, whatever jurisdiction he's going to be in, like where the person passed away or where he lived or where their assets are. That will gets deposited or filed to the court. Within 60 days, that successor trustee has the legal obligation to send a notification to all the beneficiaries. And if you have a beneficiary that's passed away, and now that money's going to go on to that beneficiary's children, those children need to be notified. If those children are underaged, then that needs to go to the parent or the guardian of that minor child. They all get notification that the trust has become irrevocable. They get a copy of the terms of the trust. They get a copy of the trust itself, and they have 120 days to object to the terms of the trust. And that doesn't mean a contest necessarily. It just means that they can object to the terms of the trust. But if that successor trustee that you're naming as your successor trustee, if they don't do their job and get all that stuff done, plus there's 28 other things that they need to do according to lists that I have. If they don't do them, the other beneficiaries can say, hey, it's been 60 days. Where's the trust? I want an accounting. I want to know what's gone on. I want to know where the money is. I want to know what the house is worth. I want to know what you're doing. Do we have a tenant or not? What's happening to the house? All those things have to be reported to all the beneficiaries. If now a beneficiary says, hey, brother, I want to know exactly what's going on. I want an accounting. As long as it's reasonable, within a reasonable period of time, that beneficiary now is entitled by law to get an accounting from the successor trustee within 60 days. If that successor trustee does not provide the accounting within 60 days, the next step could be, legally, is to go to court and say, I asked for an accounting 70 days ago, 80 days ago, 6 months ago, 12 months ago. I've asked for it twice. He's not providing me the accounting. I don't know where all the money is. We don't know where the assets are. We want him out. Or we want an accounting and we want him out, or you just want an accounting. But you go and get the probate court, and they then have the muscle to order the trustee. You either provide the accounting or you're going to pay a fine. You either, show them where the assets are, or you're going to be charged a fine. And that trustee's share can be surcharged. Okay. If that's going to happen, think about it. You need to get on that pretty quickly. So I'm still talking to mom and dad, right? Once you guys pass away, both of you, that successor trustee has to get on their job. If they don't, then their siblings, the other beneficiaries, are the ones that should be on them saying, where are the assets? And it's not being rude to say, where's my money? Because that's just a shortcut of saying it, right? It's more like, where's our family? Where's our parents' money? What's happening to that? Because one mom and dad die, all the beneficiaries at the date of death are entitled, legally entitled, not like an entitled snotty bratty kid, entitled meaning legally entitled to whatever the share of that trust estate is. And we may not know the exact dollar amount. We may not know where things are located. That will come in time, but they're entitled to their share, legally entitled. So that means it's kind of like theirs
About a minute.
legally, but there's other process that they have to go through. So they're going to be watching out to try to figure out exactly what's happening with that money and they're entitled to it. So if you're choosing a successor trustee, just choose the kid. If you're going to use your kids, choose the kid that you think is going to do a good job. If it's your toughest kid and now he's out there, hitting it hard, making good money, you're making the world a better place, that's a good choice. If she's, if she's got a corporate executive job, if she's working as a waitress, if she's, she's a mechanic, it doesn't matter. It's the responsibility thing. They don't have to do it themselves. They will hire an attorney that knows what they're doing. They will hire a tax professional that knows how to handle trusts. They will handle a bookkeeper if they need to. They'll hire a financial advisor, all these things. The successor trustee is a quarterback. Okay. All right. Now, coming up next, I want to talk, if you have been assigned to be that quarterback and your parents have passed away, I got a little bit of advice for you. Coming up next, right here on the Word on Wealth with Gary Quackenbush. Talk to you on the other side.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQLaw.com.
You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money
How was Mickey?
investing with Anthony Wright?
Or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com. 855.
We're live.
All right. Welcome to Word on Wealth. This is Gary Quackenbush. I'm happy to be with you today, and I'm so glad that you're along, listening up. We were talking on the show today about trust. It may sound something like, gosh, how could a guy talk about trust every day of the week? I don't know. I do. I meet with, anywhere for, usually we're averaging about 4 new people that I talk to every day. I get to hear their story. I get to hear about their friends, their family, their money, their woes. That's just what we do. I love doing it. I have done it for 33 years now, and I don't know. I just do it every day, and I love it. I really enjoy.
Well, and the main reason why you like to do it, because you've told me, so many times over the years, Gary, is yes, it's a great career, but you do it because you actually like to help people.
Yeah, it's really true, and it's kind of, and I'm fortunate in that way because it's kind of like in my blood. That's what I do. I like to help people, and it's a good career for me to be able to help people because some of this stuff gets really complicated. And now that I've been doing it for, over 30 years, I'm figuring it out, and I'm figuring out kind of easier ways to do things, and when you can take a shortcut and when you can't. And the challenge that I find with successor trustees, and that's why I'm telling you I have some secret advice, or not secret, I have some good advice for you coming up in just a second. But I found out things that you don't have to do as a successor trustee and things that you do have to do. And because you don't know how to do it, it's always better to get some help. So what's been happening, or what I would suggest, if you are serving as a successor trustee, the people that I've seen who are the most successful as a successor trustee, meaning the ones who had the least amount of difficulty from siblings or beneficiaries, are the ones that provide a lot of information and they share a lot. Okay. If your thought is to tell your siblings, for example, just trust me, bad idea, because that's just, for some of us, me especially, when somebody says just trust me, my immediate reaction, and this isn't always fair, but my immediate reaction is, if you say just trust me, that there's something weird. Okay. Why should you have to tell me to trust you?
Through your actions, I should already be knowing that I trust you, but since you're telling me, I'm going to kind of doubt that.
Isn't that true? Or like somebody will say, well, to be honest, I would blah, blah, blah. And I remember when I worked with my dad, it was a long, long time ago. I said some common phrase, and I said something like, he said, A, B, C, D. And I went, that's interesting. And he said, no, it's not interesting. It's just true, or something. I would say, well, to be honest. And my dad would say, Gary, you shouldn't have to say that, because that means that if you're qualifying it to be honest, then you either weren't before or you're not now, and you're trying to cover. He says you should just always be honest, which I thought was really interesting. And I try to teach that to my teenage grandsons, is like, you guys don't say, hey, trust me on this, or hey, trust me, or to be honest, or,
it's interesting.
honestly,
It's interesting that you say that. My stepson says that all the time, and it's something that I've been trying to eventually, hopefully he'll get a grasp on it, but he likes, I don't know, probably heard the phrase somewhere, but likes to use it. And it's well, you should be honest all the time.
Yeah. Well, it's because if somebody, and I ran into this, I just ran into this a bit with my grandsons, and I love them. And I think it's just funny, because I'm a teenage advisor too. And and I'll tell people there's certain things that we just don't say. Okay. Because it just, they don't rub me the right way. Not that it's all about me, but it's like, don't say, well, to be completely honest with you, or, well, if I'm going to be completely honest with you, then blah, blah, blah. I said, don't preface with things like that, and then there's just kind of funny things like that. Or if you say, hey, would you like to come with me to do this and that and the other? And they say, oh, I'm good. And I go, well, that's kind of a non-answer, because later if I say, well, you didn't want to come, and he said, no, I didn't say I didn't want to come. I just said I'm good. It's like, oh, come on, commit to something. So I just think it's kind of funny. I mean, and I think that was the phrase I used with my dad. I said, well, to be honest, I think
And that phrase is good to teach kids in families, because when they get in the real world, whereas the grandparent or parent, you might thoroughly trust them. You're just calling them out on it. Somebody else hears that, they might kind of subconsciously go, shouldn't trust this guy.
that's funny, especially when it's coming from a teenager. Trust me on this one. I don't know. And I don't know why we use it so much. I don't know, they're just certain phrases. I don't know why they bug me. Maybe I'm just getting cynical, but I just think it's with us, that's my thing with successor trustees. It's like you're a trustee. You don't ever say, just trust me on this one. Just, hey, just leave me alone. I got this. It's like, no, prove to me you got it. And that's my advice to you successor trustees is the best way. Okay. What I have found, okay, the best way to have your siblings believe you is to say, my attorney said, blah, 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 blah. Let me forward you an email from my attorney. So I was talking to my attorney and he said this and that and the other. Now, an attorney that I've personally used before is Pat. His name is Pat Callahan. So I will say, I was talking to Pat and Pat needs this or Pat wants that or Pat, because me as a successor trustee, it's not what I do for a living. I mean, I help people be a successor trustee, but I hired an attorney to be my attorney, to be a successor trustee. And so now it's like, well, Pat did this, Pat did that. Pat wants this, Pat wants this, because Pat's my attorney. And I think that's the way to help you successor trustees to feel like you're being successful, because you don't have to question what you do, because you have your attorney who's experienced, very experienced, who knows what they're doing. And that's the way you deal with your siblings or your grandkids or whoever you are being the successor trustee over their money. Another great thing to be able to say is, yeah, I know the market's tough, but we've got that money sitting with so-and-so at Goldman Sachs or at Neuberger Berman. And according to her, we're doing the best we can under the current market conditions. So is that my fault now? Right? It's not, because I've hired a professional money manager. I'm not a money manager. I am not legally allowed to manage the money without money manager advice, because I am not a professional money manager. What about the tax returns? If the beneficiaries have a question on how the tax return was prepared, why is there so much tax? Why is there more? What's with the refund? What's with the penalties? What's with all that stuff? It's like, well, my attorney did the return. My tax professional did the return. Let's ask him. So I think my biggest advice to you serving as successor trustees is you need to do what California law suggests and requires. And that is, when you are a successor trustee, you are a fiduciary, legally a fiduciary. Look up the word. A fiduciary is somebody that has to look out for the best interest of their client. As the successor trustee, you are a fiduciary, and your clients, or the people that you're looking out for, the people who are interested, are the beneficiaries, including yourself, probably. So as a fiduciary now, you must delegate responsibilities to professionals who do it for a living. Tax professional, accounting professional, legal professional, financial advice professional. Those are things that you can't do yourself. Okay, I'll go one step further. I have represented many successor trustees who were chosen to be the successor trustee because they are financial advisors. Fantastic. They know how to do financial advice. They know how to move money and manage money. They're experts at it. But they had to hire an attorney because they're not lawyers. They had to hire an accountant or a tax professional because they're not tax professionals. And get this, all but one that I've represented have hired financial money managers, even though they are a money manager, because they were smart and they said, you know what, as the successor trustee, that is what I'm going to focus on. I will be paid as the successor trustee, but I'm not going to do the money management. Because if you did the money management, if you could do it legally, because that's what your licenses let you do, you could do it, and you technically can be paid as the successor trustee, and as the money manager. But how many of you believe, by a raise of hands, how many of you believe that if you, as the successor trustee, were paid, which you're entitled to be paid. It's a lot of work, and being paid is appropriate. And if you're also managing the money, and let's say you have it under management, like most, managers do, you charge a percent fee because you're entitled to, right? So you're the money manager and you're getting a fee for managing the money, and you're the successor trustee and you're getting a fee for managing the trust. You're getting money for two different functions. How many of you believe, by raise of hands, that your sibling beneficiaries are going to say, hey, that's double dipping? Because it's not necessarily double dipping, but it's going to look like it and it's going to feel like it. So I suggest you get an advisor. Especially if you're the one inheriting the money with your siblings, get an advisor. It's not your money. It's the money that belongs to the trust under the control of the successor trustee. And his or her job is to get it right and to act in the best interest of the beneficiaries. So don't do it yourself. Get a professional. That's my best advice. It's not your money. And you don't have to pay them out of your pocket. It gets paid out of the trust. So anything you do gets paid out of the trust. Okay. Now I'm going to have to talk about this more tomorrow. So what I'm going to do for the rest of the show today, we're going to have Rich Mathurin, who's our tax attorney here at GQ Law. And GQ Law sponsors this show, as you know. So we're going to have Rich Mathurin of GQ Law. He's going to come in. We got some really cool tax things to talk about. So that's what we're going to do for the rest of the show today. Tomorrow, we're going to be talking about more things with successor trustees. I got some interesting things I want to kind of share with you, some things I'm working on to kind of show you how it works and how to be successful. Wednesday, we have Ken Pecos from the Pecos Group, and he's going to be talking to us about the real estate market today. Oh my gosh, we have so much good stuff. We've been talking about it already for like the last week. And then Thursday, we're going to have Anthony Wright. Friday, we got our Finding Joy Friday. So we're going to bring Rich in probably in a couple of minutes. We'll have Rich in here. We'll be able to talk to us about, there's some new stuff going on with the taxes. Very interesting stuff. We'll kind of give you some background on IRS stuff that maybe you didn't know. Not the back room stuff, but kind of some background, some interesting things that we get as practitioners. The number to call me is 855-500-TRUST. If you want help being a successful and good successor trustee, it's 855-500-TRUST. If you want help with your tax situation, if you're behind in your taxes, if you owe money, if you haven't filed tax returns, 855-500-TRUST. So use the same number, 855-500-TRUST. If you're driving and you can't call, just remember my website is super simple. GQlaw.com. GQ like Gary Quackenbush, law like lawyer, GQlaw.com. All right, coming up next, Rich Mathurin from GQ Law Taxes.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST. Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST, gqlaw.com.
You're live.
Right. Happy to have you along here on the Word on Wealth. The rest of the show, we've got Rich Mathurin from GQ Law. How you doing, Rich?
Great, Gary. Good to be here.
You know, I'm always glad when you're on the show, so I don't have to talk the whole time. It's always good.
Well, I love to hear my own voice.
It's with headphones on. It's like, that's really my voice. Are you kidding me? Anyway. So Rich, if you have questions for Rich, tax questions, back taxes, tax collections, whatever, the number is 888-344-1170. You can call and be on the show with us, 888-344-1170. You can call today, call now, get your question in. If you want questions, if you want to meet with Rich and talk about your situation, it's 855-500-TRUST. All right. Rich and I get, because we're practitioners, which means we do this for a living, we get a newsletter that talks about some of the changes with the IRS, which is really interesting. So I wanted to talk with you, Rich, today about, the collection thing with the IRS. We've always been saying on this show, like, hey, the IRS just got $80 billion, in their budget increase so that they can collect more money, which, I mean, honestly, I know it sounds funny, but that would make sense for me if I were the one, if I were the commissioner of the IRS and I wanted to collect more money, I would need money from Congress to be able to beef up my collection system so I can collect even more than that, because the IRS is basically the only collection agency for the government. But you said there was some change recently with the budgeting thing. What did you hear about that?
I thought I read on the debt deal that the Congress recently agreed to with President Biden that a lot of that was X'd out of the budget, X'd out of in that bill. I heard like 60 billion of the 80 was taken away, and now I think it's only like 20. Still a lot of money, but like you said, it sounds like that's probably money well spent. Where if they spend a dollar, maybe they can collect $2 in taxes or whatever. Yeah. But they did change that through the recent debt ceiling deal.
So now if you're the commissioner, so that you guys understand, is that the head of the IRS is called the commissioner, and it's an elected guy, and every couple of years they get a new head of the IRS. Well, if you think about it, the head of the IRS, it's dealt with just like, it's like a regular company. It'd be like, if this guy were the head of, Verizon or something like that, he still has to account to, Verizon guy has to account to his shareholders, right, for how much money they're making and bringing in. Well, the commissioner of the IRS has to account to Congress, like, are you justifying your salary? Are you justifying the 80 billion or now 20 billion that we're giving you to collect money? Are you justifying it? So believe me, they don't just go, oh, darn, we don't have as much money. Oh, well, I guess we'll just go on vacation. He's trying to figure out ways to get more money. And the interesting thing in our tax news we're talking about today is the IRS has some really tricky ways of getting money. Now, I want to talk about, and Rich will comment on the IRS thing. If I were collecting and I were not an IRS creditor, so let's say that let's say Rich owed me $20,000 and I wanted to get it from Rich, and he refused, and he basically just blew me off. So then I would go to the Superior Court and I would file a lawsuit, a collection lawsuit, and I would sue Rich for $20,000. And if he didn't respond or anything like that, and just kind of still just ignored me, I would eventually be able to convince a judge, if I had the right documentation, convince a judge that Rich owed me $20,000. Okay. That would take me about 6 months. Once I got to that point and they said, okay, Gary, Rich owes you $20,000. Here's your judgment. Okay. Now I have to collect the money. So I send it to Rich. And I say, hey, I got a judgment against you for $20,000. Is Rich going to go, oh, gee whiz, I'll write you a check? You're not going to, right, Rich?
Probably tell you to pound sand. I
You're
can't
gonna
afford it.
Pound sand again. So now I have to go and try to get the money, like take the money from him. I literally would have to go back to the judge and say, hey, judge, you gave me this order against Rich for $20,000 and he didn't pay me money. I want to do it involuntarily. I want to take his money. I want to take his wages. I want to take his bank account. I want to take, his home. I want to do something. And the judge says, well, where does he work? I don't know where he works. The judge will say, go figure it out. And when you know, let me know. So I got to go to the judge and say, oh, he works at such and such a company. So I want a levy against wages for that company. And I want to go after his bank because he banks at Wells Fargo, whatever. So I want a levy against Wells Fargo. This is another like 3 to 6 month process. So I'm talking about when I'm begging him to pay me and he blows me off, I'm a year later and I'm still trying to find, a way to get his money. And who knows what he's been doing with his money in the meantime. I'm sure he's putting more and more money in the bank and just waiting for me to go there, right? I kind of doubt it.
Quit my job and we're living on a commune now.
There you go. But if it were the opposite and it's not me collecting money from Rich, it's instead, let's flip the thing. And now Rich is the IRS guy. Okay. And he wants to collect 20,000 from me. So Rich, go through the process.
Well, they would send you notices of your amounts owing, and then they would have I believe a 90-day notice and then a 30-day notice. And after those 30 days have expired, they don't have to go and get a judge's order. They don't have to file a lawsuit. They don't have to do any of those things. They get automatic lien rights where they can file a lien on against all your property located in a particular county. And then they can levy your wages, garnish your wages, levy your bank accounts. They don't need a court order. I believe the bank has to hold on to the levy for 21 days, but after that, they have to turn the money over to the IRS automatically. The only way you can possibly get that levy money returned is to get some type of an agreement with the IRS. But it's like they say, they're the most powerful collection agency in the world.
And with that, so then Rich being the IRS, he then wants to figure out where my money is. There's a recent Supreme Court decision, Supreme Court of the United States upheld the IRS. And what they did was they actually can send summonses to my bank, to people that I work for. They can summons information about me without telling me. Now, if it were me trying to get that information from Rich because he owed me $20,000, if I do summonses, I have to notify him. It's a consumer summons. I'd notify him, by the way, I'm getting your bank records, and he can object to that. By the way, I'm levying your wages. I'm going to give you a notification. All these things, if it's in the regular consumer world, he has the right to keep objecting. With the IRS right now, the way the law is set up, if Rich wants to get money from me and Rich is the IRS, he can just go and he can summons my bank without telling me. He can go to third parties and ask questions about me. He can go to my neighbors and say, hey, so is Quackenbush home very much? When does he get home? And they can track my whereabouts to figure out where my money is, where I work, even if I'm trying to hide things. So the IRS is super powerful. But on the other hand, if you and that's usually if you don't cooperate with them, right, Rich?
Yeah, they definitely. I think that's the thing that probably angers them the most is when you don't respond to their notices and you don't try to communicate and say, tell them what's your situation. If you're in the hospital because of a medical condition or you lost your job or whatever, that's fine. Just tell them. I think that, like I said, it's where you just kind of totally ignore them and make them jump through all these hoops. That's what really angers them.
Yeah. And I that is really the key. And that's what we have found over all the years that we've been doing this thing is when you work with the IRS and it's not like playing their game, but that's kind of the vernacular, right? If you play the game and you do it right, then there's ways to get maybe an offer in compromise or maybe a payment plan or something. And that was one of the things even very, very recently, the IRS, and this tell them about, we were talking about where the IRS actually got slapped because they weren't considerate enough, I guess.
Yeah, I guess somebody had submitted an offer and the IRS kind of, I think, rejected it out of hand because the person had equity in his home.
Which makes sense. The guy has equity in his home, which far exceeds, the tax liability, and the IRS just kind of dumps the offer and says, forget it. You can full pay, offer rejected. But what happened?
The Supreme Court kind of returned it and did slap the IRS's hand and say, you didn't handle this well, but they just returned it to appeals. I don't know that really does that much. You're sort of back in the same scenario you were before you submitted the offer. The appeals, if there's new information or they didn't calculate things right, maybe they didn't have the right calculation of equity or something like that, maybe that's way you can get an appeal through. But appeals basically it's looking at the information that you submitted at the time of your offer, and they can reconsider it. You have new information or whatever. So I did have a case recently where a client, their life changed, the offer was rejected and their life changed 180. And so they asked for new information. That was a rare case though.
Okay. So basically what's happening then is like this thing is the IRS, their hand slap thing was that they just looked at the offer, said, oh, you don't qualify, you've got equity, and they rejected it out of hand. Where it seems like now the IRS has to kind of comply with the Fresh Start initiative, which is really consider whether can the person really afford it, what is their age. I mean, you found that, right? I mean, people are a certain age, they're getting close to retirement, or they are retired. Maybe there's equity in a home, but maybe you can still get an offer depending on circumstances. What we're going to do is coming up next, we're going to keep talking to Rich. We got Rich Mathurin from GQ Law. If you want to get a hold of him to talk about your tax situation in particular, it's 855-500-TRUST. To get a hold of me to talk about your estate planning, trust administration case, 855-500-TRUST. When we come back, we're going to talk a little bit more about what can you do if you get stuck and you owe money and you fell behind. What are your options? More with Rich Mathurin on GQ Law.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com.
Gary, how do you and your team help our listeners avoid probate?
Well, first of all, probate is a process that involves attorneys, judges, and sometimes contesting parties. And so we try to avoid probate at pretty much all costs. The way we do that is setting up living trusts, setting up properly documented wills, putting the property like houses, cars, bank accounts in that trust so that it avoids probate. Probate is only necessary if the estate plan isn't set up quite right. So we help them get it set up right. And mainly that's done through a properly created living trust.
Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free initial consultation. That's gqlaw.com, 855-500-TRUST.
What aren't we being told about the COVID-19?
Need. Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com, 855-500.
Alive.
Right. You're listening to Word on Wealth. We've got Rich Mathurin of GQ Law and me, Gary Quackenbush of GQ Law. We're talking about taxes and tax situations today. Rich is talking to us about different ways that the IRS tax problems, franchise tax board tax problems can be resolved. It's not, maybe when you have a tax problem, it's not like the end of the world, It is difficult. I know it's a personal thing. The IRS is taking your money. You don't like it when they go poking around your bank account and trying to take your money and levy you. That's just, it's a horrible, humiliating thing to have to not have money because the IRS took it. Well, Rich is talking to us about some different ways to go about resolving it. Rich, I wanted you to address a little bit more about this information we got with the IRS has actually come out and warned people about going to the wrong person to solve your tax problem.
Yeah, I think that when they say that they can settle it for pennies on the dollars, then they're not going to review any of your information and guaranteed results. I would run and hide from those people. The IRS there are all programs for all different types of taxpayers, whether you have the money to pay in full, whether you have no money, you can't pay, whether you could possibly do a bankruptcy. There are a lot of possible solutions, but please, a lot of times, to settle for less than you owe, you're going to have to, what I say, show your card. You have to provide financials to the IRS. If you have equity in your home, if you have a bank account with $100,000 in it, if you have a retirement account with hundreds of thousands of dollars, those are going to be considered by the IRS for not allowing you, if you want to not full pay, though you probably are not going to get a offer in compromise through, or we may be able to get you into a partial payment installment agreement if you do not have a current income to fully pay your balance. But if they do not ask to see your financials before advising you on a way to deal with the IRS, again, I really think that's highly suspicious.
Okay. And I think the one thing, along with that, Rich, and I appreciate you explaining that, is when the IRS comes out and warns the general public saying, hey, there are offer mills out there, offer and compromise mills, then that's a serious problem, in my opinion. And in fact, it says specifically in the article, it says the IRS, let's see, the IRS's term is called offer and compromise mills. The IRS's term for firms and promoters that hawk tax debt relief plans with promises to settle your debts at steep discounts, even pennies on the dollar. Many advertise on radio and TV, charge big upfront fees, and churn out applications for relief that some of their clients can't even qualify for. And I think that's the big thing. Now, Rich and I talk about this a lot. The IRS's system for collections is flawed. It's not perfect. And the IRS, part of the system is that if you put together the IRS's form, a 656, even if it's not done right, if you submit it, the IRS has to stop collections, right?
Mm-hmm. Yeah, they do have to review your offer to see if it's something that's will fly. But they, at the same time, you have to deposit 20% down of your offer. They keep that if they reject it. And if they feel like you can full pay with the equity in your home, equity in retirement, equity in other assets, they can just return it, keep the 20%, and you're out the fees you paid this this offer mill company, and you're back at square one. You do stop collections for right. Let's say 3 to 6 months type of thing, but that time is what they call tolling. So that'll stop the statute of limitations from running on your balances. And after 6 months, you're right back where you started, and you're out probably tens of thousands of dollars.
And I think that's the point that we're making, right, Rich, is that if you submit an offer and compromise, and it's done, I don't care whether it's done by, whoever, whether you do it yourself or you do it by some, quote, offer mill firm, if they submit junk and they submit your information and it's not correct, when you go to try to fix it, because we've run into this, the IRS, somebody will come into us and say, my offer got rejected. We look at the offer and compromise and go, my gosh, it's like somebody did this application with a blindfold. All of your bank accounts are not there. All of your assets are not listed. It was done messy. And we've had people say, well, but they didn't ask me about my bank accounts. They didn't ask me for this. They just filled out the form for me. And to me, that's really alarming, because you as a taxpayer are signing that form, and it says you're signing under the penalty of perjury, that everything on there is true and correct. Okay. So you may be kind of innocent in not knowing what should have gone on there, but you sign it under the penalty of perjury that it's true and correct. And that penalty of perjury thing is where you get stuck. because the IRS now, when you go to resubmit the form, and lo and behold, now you have listed that third car that you didn't list because it wasn't running. Well, that has to be listed. And you have that bank account that, well, you were joint with your daughter, so you didn't think that has to be listed. It does. And you forgot to list your retirement account because this firm, this mill, didn't ask you about that stuff. Well, you signed in under the penalty of perjury. So now the IRS is going, okay, were you lying then or are you lying now? So our advice to you is do it right the first time. Get a competent attorney that knows exactly what they're doing, knows the ins and outs of the process, full disclosure. I had a case, Rich, years ago. I haven't talked to you about this one. I'm doing an offer in compromise, and I'm with, we submitted the offer. They paid their deposit. They paid their 20% down to the initial offer. I thought I did a good job calculating it. And then I'm talking to the agent that's reviewing the offer specialist. And they said, well, Mr. Quackenbush, what about his jet and his boat ski and his Suburban? And I'm like, I mean, immediately I'm feeling myself getting heated up, like, oh my gosh, my face is turning around. I'm going, what non-disclosure? That's perjury. So I said, well, give me the details. They said, yeah, here's the number. It's a CF, blah, 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 blah. And it's a such and such jet ski. And then there's a Suburban and whatever. And so then I called my client and tried to explain it because I was really upset. I thought, this guy lied to me. So I said, I was talking to the offer technician, and they say that there are 3 vehicles that you didn't list. What? They accusing me of lying. I'm like trying to calm down. Like, no, just hear me out. Here's what they said you didn't have. They said you didn't list your jet ski. And he said, that jet ski, I had that 6 years ago and it blew up and I took it to the dump. I said, okay, that's a good explanation. And what about the Suburban? The Suburban, I sold it 2 years ago. I said, well, apparently nobody told the IRS. He said, are you supposed to tell the IRS? I said, no. But the DMV still has some record that you owned these things back in the last 4 or 5 years. So the IRS was going and they got DMV records, which I thought were confidential. But I know now, if I'm suing, like our story earlier, if I'm going after Rich for collections, I can go to the DMV and pay $3.50 and get your records of all the cars that you've ever owned for $3.50. Now, maybe more. This is a while ago. But I can do that because I'm saying I'm trying to collect money from this guy. Give me the records of the DMV. Well, the IRS doesn't have to they don't get charged money. They do it for free. They look on county records. They look on your credit report. They do all these different things. So they know about stuff in the past. So when we submit offers, we're really good about getting everything, even past stuff. So the IRS, the way to, quote, play the game properly is to get somebody that knows what they're doing. You don't want to submit an offer that's junk. I mean, we've been to appeals where the appeal officer is saying, well, we noticed that 5 years ago, there was a bank account with X amount of money in it, and it just seemed to go away. What happened at $30,000? So I don't know. Talk to the client. The client says, oh, yeah, that was a bonus I got, and I spent that on my daughter's wedding. Okay, that seems fair. I talked to the IRS again, and they said, no. At the time that he spent the $30,000 on his daughter's wedding, he owed us $125,000. That's a
dissipated asset.
Yeah. You had the money. You didn't give it to us. I mean, okay. Honestly, it sounds, well, first of all, it's $30,000 on daughter's wedding. I'm not judging here. It is a lot of money. But the IRS is saying, look, you had the money. You spent it on something that, whether it's reasonable or not, we don't care. You should have paid your taxes instead of paying your daughter for her wedding. But anyway,
college tuition is another one where
that's right.
I think they'll allow one semester, the current semester, whatever. But if Johnny is going to Harvard right now and you're paying for it, you may have to, Johnny may have to go to a community college for a couple of years to allow that money. The IRS says that money should be used for us. I've had other charitable contributions where one of our clients was a very religious and contributed the tithes every week, and he donated a lot of money, and the IRS said it was a dissipated asset. They felt that money should have been paid to them instead of his church. So you have to be careful with those things, but you should have somebody that knows these kind of
exactly.
I had a client that didn't disclose that she had a job and had a retirement. It was a small job. It wasn't a big paying job, and it was a small retirement, but the offer specialist did find it And I had a great relationship with her, and I kind of got her, she increased the offer by like $400, but we got an acceptance, but they will find the information if you don't disclose it all.
And I think that's really the key, is get somebody that is acting in your best interest to get the offer put together right. And be honest with you. I mean, Rich, if the offer's not going to work, we're going to say, oh, let's submit it anyway. No,
I always go over with this is how much it's going to cost. This is the things, these are the issues I see. I think we have a good chance, but so
Yeah.
I do, the client should make sure that they sign off before we submit it.
you got to do it right. If you want to do it right, let's talk to Rich, 855-500-TRUST, 855-500-TRUST. Call Rich and get an appointment with him to talk about, whether you qualify. We'll be honest with you. What are your best solutions, your options? Let's figure out a game plan. 855-500-TRUST. We'll be back again tomorrow here on the Word on Well, same time, same station, finishing up how to be a successor trustee. Bye, everybody. Thanks, Rich.
Thank you.
Tell a friend about the Word on Wealth, featured since 1995. With financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future.
The information you hear on the Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual legal needs. The opinions expressed here do not necessarily represent the views of Salem Media Group or its sponsors.